This is our last video of the year, and it covers attorney fees. Let's start. The British system awards fees to the prevailing party. The American system, the default is parties pay their own fees, unless a bunch of exceptions, right? Fee shifting arrangement, family loss cases, collateral litigations, litigation misconduct, or statutory exceptions. So, at first glance, the American system makes it look like parties have to pay their own fees and it's harder to get attorney fee awards compared to the British system. But in reality, we have so many exceptions that it somewhat functions the same as the British system, where the prevailing party gets fees. There's also this common fund rule that's on page 895 that you don't have to know, but there's all these exceptions for class actions or shareholder derivative suits. And why does the American system function this way, where it says you have to pay your own fees but creates a lot of exceptions instead of just being like the British system, which says, well, we're going to award fees to the prevailing party? And the answer is deterrence. We have so many litigious people in America, so many lawsuits, the courts are clogged. We want to discourage people from suing each other and encourage them to settle or figure things out on their own by saying, well, you have to pay your own fees unless one of these exceptions apply. So now let's look at our case to see how this works in practice. So, what happened in this case? Well, we had plaintiffs who operate a care home that failed an inspection, and this care home was ordered to be closed. On October 1997, these plaintiffs brought a suit requesting injunctive relief that the self preservation requirement violated the Fair Housing Amendments Act of 1988 and the American Disabilities Act of 1990. I think they also brought declaratory relief. In 1998, West Virginia, which is a state, enacted two bills eliminating the self preservation requirement, and then the defendants moved to dismiss the case as moot. And the district court granted this motion because that was the whole basis of the plaintiff's suit, which was the self preservation requirement violated these acts. But now that this motion was granted, the plaintiff is still requesting attorney fees as the prevailing party under the FHAA. So, what was the rule used by the court to determine its holding, which was ultimately that the plaintiff could not get attorney fees? Well, that rule fell under the statutes that are listed on page 897, paragraph 2. The court, in its discretion, may allow the prevailing party a reasonable attorney fees and costs, including litigation expenses and cost. And remember when we started in the beginning, as a general rule, Americans must each pay their own attorney fees unless there's some explicit statutory authority that allows attorney fees to be collected. And so here, under these two statutes, the FHAA and the ADA, the statute has specifically said the prevailing party can recover reasonable attorney fees. But what part of this rule statement needs further defining? And this was the whole purpose of the case, which was to determine, well, what is a prevailing party? And of course, we also have to determine what's reasonable attorney fees, which is our second case. But let's first deal with what is a prevailing party. This court said there are three possible ways to define what a prevailing party is: someone who gets a judgment, right, regardless of the number of damages, someone who gets a consent decree or a settlement, right, giving some legal relief sought, and then someone whose lawsuit brought about voluntary change in the defendant's conduct. Now, a judgment is pretty universally accepted because it's an actual order that is made. But why is a settlement or consent decree considered a basis for the award of attorney fees? Why is someone with a consent or settlement, a consent decree or settlement considered a prevailing party? The court said, well, a court ordered consent decree still creates a material alteration of a legal relationship of the parties necessary to permit the award of attorney fees. So they're similar to the judgment. Now, the third issue, voluntary change in defendant's conduct, was the main analysis of this case. And the issue that was addressed by the US Supreme Court here was, can attorney fees be awarded under this catalyst theory, which is what it's called, the voluntary change in defendant's conduct? We said yes to judgment, yes to the consent decree, and yes to settlement, but the court said no to this catalyst theory. It says the catalyst theory is not a permissible basis for the award of attorney fees under the FHAA and the ADA. So essentially, it rejected the argument of the plaintiff and said, I'm sorry, you cannot collect attorney fees because your case is now moot, and that voluntarily, West Virginia voluntarily changed the statute. However, the catalyst theory is not completely dead. There are other states that use the catalyst theory specifically in its statutes, and the Freedom of Information Act uses the word substantially prevailed instead of prevailing party that requires the judgment, consent decree, and settlement. But what are the policy reasons behind not allowing the catalyst theory to be permitted here that denies relief to people like our plaintiff? The court says the catalyst theory lacks judicial imprimatur, which is acceptance or guarantee. So there's nothing that the court has guaranteed by the defendant's voluntary change that the defendant is going to keep continuing this course of action. The defendant could just change back. So there's actually no prevailing party in this situation. We just have a voluntary action. Legislative history also explicitly defines a prevailing party as limited to a victor only after the entry of a final judgment. Voluntary change of inaction has no judgment at all. However, the dissent and the petitioner said that legislative theory requires more of a broad reading of prevailing party. Also, the whole mootness concern that was raised in this case about the defendant purposely doing this voluntary action just to moot the case and then going back to normal after says it only applies to equitable relief. If there was declaratory relief or legal damages being requested, the defendant changing the behavior wouldn't moot the action and they'd still be able to get a judicial decree or consent decree or settlement. However, the petitioner said by allowing this catalyst theory to not be considered under the prevailing party rule, we're encouraging defendants to moot the action. Both are valid, but the majority won out in this case. The majority also said the possibility of attorney fees without the catalyst theory has already deterred defendants from the wrongful conduct. We don't need the catalyst theory also adding fuel to the fire. The dissent petitioner said if we don't allow the catalyst theory to be considered, it will deter plaintiffs with meritorious cases that are expensive from actually litigating because if the defendant moots the case, then they're not going to be able to cover attorney fees. The majority says, yeah, well, that's true. However, we want to encourage settlements, and allowing the catalyst theory as a basis for recovering attorney fees might discourage defendants from actually settling or, changing their behavior. We want to encourage people to solve things on their own. Also, they said, yeah, it might be a good idea even if we accepted it, but it's not ready for administration. And we want to avoid this second major litigation that's going to determine, well, what was voluntary change? And was the voluntary change actually because of the lawsuit or just something that happened? So main takeaway from this case is there's this thing called the catalyst theory. It's not accepted universally. It is accepted in some states, but in general, you have to have the judgment or a consent decree or a settlement to be considered the prevailing party. We've defined the first part of the rule, which is prevailing party, but what's the second part? What is considered reasonable attorney fees and costs? And this is where we had the Lone Star method, where I asked you to skim the Baxter case to understand this. There's a two-step process. The first step, you take the hourly rate and you multiply it by the number of hours spent on the case. This gives you your starting base for the amount of attorney fees that are being requested. Step number 2, you adjust upward or downward based on these 12 factors. But let's first start with step number 1. How do we get our base rate in this Baxter case? Well, what was actually awarded was $121K in attorney fees to the plaintiff. But how was it calculated? Well, the plaintiff's attorney, Mr. V, billed 726.85 hours at a rate of 175 per hour, even though the total hours worked was over 1,000. He reduced the hours by 300 for the paralegal and secretary work, plus travel time, calls, and depositions with the client. The defendants argued that's still not enough. The number of hours devoted to this case and the rate of compensation were considered excessive, and the plaintiff's attorney fees failed to exercise proper billing judgment. And so now what's the issue addressed by the court? Well, the court needs to look at all the facts and those factors in step 2 to determine, well, are the attorney fees and costs in this case reasonable? We've already done step 1, which is the hourly rate multiplied by the number of hours spent on the case, which is about 172K. So you could see the original court lowered it by about 6K, but the defendant is saying it needs to be lowered even more. And so now let's go to step 2, which is adjusting upwards or downwards based on the following factors. And let's first start with the time and labor required for the case. This factor you want to look at, did the attorney expend a reasonable amount of time and labor on the case? Or was there a lot of unnecessary stuff being done, like motions, research, document review, meetings, and long responses? And in this case, we had 25 hearings, 30,000 pages of defendant documents, responding summary judgment, meetings with opposing counsel, experts, depositions, discovery disputes, jury trial, post equitable defense hearings. We also had jury instructions, but none were used. It was a multiple party situation where we had 7 defendants in 4 separate actions, and the defense had 2 law firms and 4 lawyers versus the plaintiff only had 1 attorney plus Mr. P and his firm as co counsel. So there was a lot of stuff happening here. And so reasonable minds might differ as to whether this was too much or too little, but the court here determined this time and labor was excessive and warranted a reduction. As to the other factors, let's look now at the novelty and difficulty of the issues, the skill required to litigate, the attorney's experience, and the desirability of the case. When looking at these factors, if the case is more difficult, requires more skill, or is undesirable, then the rate will likely be higher and more hours will be likely required, right? Because it's harder to do or nobody wants it. But it also depends on the attorney's experience and ability. A more experienced attorney and reputable attorneys can charge higher rates, even if the case is less difficult. And so here we had a breach of contract case, but it still required a high level of skill because it required multiple areas of law. And then if we look at our attorneys, first attorney, Mr. V, has experience working for 2 justices and has been in private practice for a long time. The second attorney, Mr. P, has a reputable academic background, plus a good reputation in the community. So the court determined this case was pretty novel. It required them to have specific experience to litigate it, which they both had. So the actual rate, 175 per an hour, was reasonable, even though the amount of time spent on it was unreasonable. But to continue on, they still looked at other factors, which was the customary fee for similar work, the amount involved, and the results obtained, as well as awards in similar cases. When you look at these 3 factors, you want to look at were the fees charged in this case similar to other cases and reasonable based on the community standard. But if the fees are equal to or higher than the amount of damages awarded, you want to be careful because it appears that it might be excessive. But you have to look at it in the context of all the other factors as well. And so here again, we got charged 175 per an hour, and the case involved 153K in damages. But again, the court said based on their experience and what was needed for the case, this rate is consistent, if not lower than what's provided by others doing similar services. And even though fee awards that are higher than the judgment amount are permitted, in this case, we're not even dealing with that issue because it was substantially the same. The fee requested was 127 and the amount awarded was 153. If they were requesting 200, 300,000, we'd want to be looking at it with a little bit more scrutiny, given that the actual amount awarded to the plaintiffs was only 153K. Now, continuing on with these factors, because we want to make sure we look at all of them, we're now looking at the ability of the attorney to accept other work and the time limitations imposed by the client or the circumstances of the case. If there's a strict time limit, then the attorney cannot work on other cases. This will impact the time and labor that is considered reasonable in the case, as well as the fee charged. Court said this case did take all the attorney's time, especially after the discovery was fast-tracked, which prevented the attorney from working on anything else. However, they still said that the amount of hours was still too much, and then they affirmed the 175 is okay. And there was also this contingency fee agreement with the plaintiff. So where does this contingency fee agreement play a role in this analysis? Well, it's one of the factors, whether the fee is fixed or contingent, as well as the nature and length of the attorney-client relationship. And so courts will always consider the contingency agreement, but it's not going to limit their attorney fees to that amount. It's going to look at all these 12 factors, just like we did today. Also, it's going to look at the attorney-client relationship to see if it impacts whether they negotiated the fee to be higher or lower, right? Sometimes there are discounts, sometimes you're helping your friend, sometimes you do a contingency agreement because the person can't pay. It just depends. And we're not going to let this agreement between those 2 parties impact what the defendant has to pay. Because you have to remember the losing party is paying the fees, not the actual client. And the contingency agreement, as well as the attorney-client relationship, is a relationship between the client and the attorney. And that should not now penalize the client when the client won the case. But naturally, the losing party will always want a judgment that states the fee should be lower, and the attorney of the winning party will always want a judgment that says the fee should be higher. And in this case, even though there were a lot of factors going towards 127K being a reasonable amount, like the complexity of the case, the reputation of the attorneys, the amount of time it took, the court decided the actual time and labor, when it looked at what was actually done, the number of hours was too much, which still warranted the reduction. But again, it's a very factually based analysis, and you want to go through the factors that are relevant if you see this type of question on the exam.